Sharon.
Hello, everyone. We're just working through getting everything started up. We are so excited for our April HIPAA Huddle. So for those of you guys that don't know, this month is our 1-year birthday of the HIPAA Huddle. So a big thank you to everybody that has made this possible. It's been an amazing year of providing this community for y'all, and we are super excited that you have joined us this month for our birthday HIPAA Huddle. So thank you to everybody who's made this possible. So we also want to welcome all of our new huddlers. If this is your first HIPAA Huddle, the biggest thing is don't be shy. Speak up. We want to hear from you. The whole purpose of the HIPAA Huddle is to network and collaborate together on the questions that y'all have sent in to us to get answered. So if you hear somebody on the call that you want to be introduced to, let us know, and we are more than happy to facilitate those introductions. Also, if you don't know who HIPAA is, if you've never heard of us, we are a compliance platform that helps you administrate your entire compliance program, from creating your policies and procedures, training your employees, and everything else that you need to be in compliance. We have it all in one place in a single platform. And we have a special offer because it is HIP Week, oh my goodness, Health Information Professionals Week. So we are waiving our onboarding fee for anybody who decides to schedule a demo in April. Jane's contact information is on this slide, sales@HIPAA, or the phone number 314-272-2600. We also want to announce that we are giving a webinar with one of our premier partners, Matterform. That is coming up on Wednesday, April 28th at 12 p.m. Mountain Time. There will be a link to register for that webinar when we send all of the follow-up information. So everybody will be getting a copy of the slides that we used today, as well as the recording of the call. So you will also get a link to be able to register for this webinar. We also have a super exciting announcement because the HIPAA Huddle community has been so amazing. We have over 500 HIPAA huddlers now. We created a web community as well to continue these conversations while we're in between these live HIPAA huddles. So you can go to that URL and for free join this community to be able to continue to network and collaborate with your peers across the country. So now we are finished with all those announcements. We're going to go ahead and get started. As a note, this call is being recorded. Your mic is now muted. Thank you, Cheryl. But when you do want to speak, simply unmute yourself. If you want us to see your lovely face, you can turn your video on as well. We would love to see you. And remember, again, that the more you participate, the more we all gain. We do have some lovely experts on the huddle that have made this entirely possible. We have Sharon Kamowitz, who is a healthcare attorney and privacy consultant out of Boston, Massachusetts. She works across the country helping ensure business associates and small covered entities maintain their compliance. We also have Erin McLean, who is another healthcare attorney and healthcare privacy and security consulting out of Billings, Montana. She also works across the country, and they are both active participants and contributors to the huddle, and we greatly appreciate and love them for everything that they've given to this community. So we look forward to continuing to hear from them. As a note, because Dina Castricone was not able to join us today, I still do want to give her a huge shout out because she is another person that's made this first year of the HIPAA Huddle incredibly productive. So now we're going to get into our first few questions. So the first question is, I had an interesting scenario last week, wondering how other facilities handled this type of situation. I had an amendment request for a change to a note, and the provider is no longer working at our facility. Is it okay to deny the request based on the fact that the provider is no longer at the facility? I searched everything that I could get my hands on and did not find anything that stated you could not deny for this reason. This is actually a really good question, and patients now are becoming more and more savvy of what their rights are. And so you're going to see more patients requesting amendment requests as well as access to their records. And this is a perfect example of some of the little glitches that can come up when we are doing amendment requests. So now I'm going to open up the floor to anybody who wants to take a stab at this question.
This is Kimberly Shutters.
Hi, Kim.
Hi, I'm going to say that they have no basis for denial. And the reason why is because patients do have the right for amendments. Just because the provider is no longer working there, another provider in the organization could add comments to, depending on what the patient wants added, but the patient does have a right to make the amendment.
Excuse me, I do agree with that. And I'm curious as to how other facilities are handling this. So Kimberly, for those that don't know Kimberly, she is with HIPAA Ally.
Wow.
Yeah, she's amazing.
Sarah, this is Joni, and how do you get a provider to take that responsibility?
Enter your meeting.
Oh,
I don't. My providers don't want to take on that responsibility if they didn't see the patient. They don't want to make the amendment.
right.
We had one a few
Enter
years
your
ago.
participant ID followed by pound. Otherwise,
And
Cheryl, can we find who's talking?
I'm working on
in
it.
the meeting now. There are more than 60 participants in the meeting.
Okay, I think we found it. Thank you. All right, now Joni, go ahead. I apologize.
Okay. Well, my providers, of course, I think we're all going to see this more and more. I agree with you, Sarah. But Kimberly, my providers don't want to take on that responsibility if they didn't see the patient. They don't want to amend the note. Now, I've had better luck if it was a nurse practitioner and their collaborating provider. That's a little easier, but to get them to do it is the hardest part.
Right.
I agree with Joni. We had somebody came in and wanted their records amended, and the physician is no longer in the area and had retired quite a while ago. Nobody else wanted to do that. What we did is we left her request for the amendment in her file, and anytime something was sent out, that her letter of request for the amendment would go with a statement from the hospital saying, we cannot verify the information due to the fact that the physician is no longer practicing. So, I mean, this is her amendment. This is how she feels. And we just couldn't amend the record because there wasn't anybody there to do it. So that was our answer to that.
This is Parthiv. Hey, Sarah.
Hi, Parthiv.
Hey, so I'm going to play devil's advocate here.
Okay.
Let's say whatever was entered by the previous provider is not right. Because I've seen when I get discharged from hospitals, at times I've read my own discharge papers, and gosh, you'll be shocked to see what's in there at times, right? I scratch my head. So if there was an error made by the previous provider, which is now latched onto my records, and I look at it and say, wait a second, this is not accurate, you need to make the change. Then what is the responsibility? Because it's that practice. I was at, whether it's a hospital or you know what I'm saying? So where does the responsibility lie to amend and change that information, because that information is false, right? Let's say if you come to that conclusion, then would you change it?
Right. And I honestly think that, and I'll let Sharon or Aaron weigh in on this because they're the attorneys, but my opinion is it's going to really depend on what's being requested to change, right? If it is like a change in the demographic information, I think that is an easy enough change that should be changed. If it is a wrong diagnosis, then where the patient can actually come in and say, hey, you know, it says here, I have diabetes type 2, you know, but I really have diabetes type 1, you know, and they come in and they request that change, and that's something that should be changed as well, right? Like, I think that there are things that we should consider even if the provider is no longer at that place, and it really should be a case-by-case basis. I don't think that there can be any type of blanket that's thrown over this that says you must always do it this way or this way. That is not what I think the rule is stating. So I'm gonna let Sharon or Aaron weigh in.
Yeah, I was gonna say there's a lot of unknowns. First, my first question is, was there an attempt to reach that provider? I mean, one of the people said that they had that situation, the provider had retired, but maybe the provider is reachable. The other thing is the determination is made of whether to accept or deny the request is made in consultation with the treating physician, and an evaluation of the whole record and any other professionals involved in that patient's care. So you have to do more than just say, oh, the provider's not here, therefore we can't make the amendment. And I like the idea of, if you absolutely can't answer the question, noting it in the record, because obviously, you know, as you all know, you don't really change the record. You do it by noting that you changed the record.
Right. I think I agree with both of you, because that's what I was looking at, is that it's not a blanket, rule that applies, or a decision that needs to be made unless and until you look at it. But there's a flexibility in there, right, based upon what's being asked and whether you can do that or not. And then obviously, again, normally a lot of places you have a referring physician, your internist referring you to, get X, Y, and Z done, and then those reports go back to him, right, from what the overall treatment should be. So again, it depends on the situation. So all I'm saying is I wanted to be sure that there's no blanket way of treating it, which is exactly what you guys said. So appreciate it. Thank you.
All right, perfect. Awesome. So are there any last comments on this issue before we move on? Perfect. Oh, hold on. It looks like we have a comment in the... I'm going to be honest, y'all. I can't really read the chat. I saw something pop in though.
Want me to read it?
Yeah, sorry. I have on my wrong glasses, the ones that don't have, I'm old. I need trifocals. I don't have my trifocal.
So this is the comment. I'm working on an amendment now. There is a surgery mentioned as history. RN who entered it is no longer on staff. The patient states it affects his worker's claim, compensation claim.
And that's a nurse that made I think, was it a nurse practitioner or an RN nurse?
It says an RN who entered it is no longer on staff.
Well, that's easy enough, because you should go to the medical provider,
Yep.
right, that actually entered it and see what was done. And and see whether or not that surgery happened or didn't happen, and what the effects actually are of that surgery. And that is something that a medical provider can actually do for the patient, right? Because I always struggle when RNs are making some notations without review from providers because of these types of situations, right? And 100% you should rely on your RNs and other clinical staff to make, H&P type of notations in your notes, like especially the history part of it. They're more than capable and qualified to do so, but it does need to be reviewed by a medical provider. And so if it wasn't properly reviewed by the medical provider, then the patient is correct in asking for the amendment.
Hi, thank you. This is Sandra. I actually typed the question. This is really important now because with the Cures Act and information going to patients portal, we are seeing a high number of, hey, this is not in my history, what is going on? And so the amendments are coming back. And then in our case, we have a lot of legacy records. So it's tracing back information 5 and 6 years and trying to make some sense of it before we say, hey, no, we can't amend. And so I thank you for sharing this, because I think it's something we are all going through at the moment.
Yeah, it's going to be a continued pain point. So thank you for sharing, Sandra. All right. Next question.
We are hoping to go to Hawaii.
Possibly. Oh, me
Possibly.
too. I want to go to Hawaii. Whoever's talking, take me with you. So next question. We recently received a request from a patient on a form they entitled Patient Access Request. They are requesting their records to be sent to a company called Chart Squad. They are also requesting behavioral health records. We have never seen a form like the one the patient provided. They are also requesting that Chart Squad be designated as their personal representative. Can you make an organization your personal representative? Ooh. Most times no, because a personal representative isn't just the person who's receiving access to your records. Your personal representative has certain things that they can actually do for you. I'm gonna hand this over to Sharon because I probably will dig myself into a hole here.
Yeah, I was going to say I think it would be risky. Whether you can do it would depend on your state law, because personal representative is defined in state law. So there may be some state that allows it. I don't know, but I think it would be risky because unless this chart squad consists of one person, the person wouldn't know if what's going to happen with their records. But if it's allowable in state law and the person has done that, then I think you would have to honor it. And I think if the question, and the other point of the question, if the question is the form sufficient, the patient can use any form. There doesn't have to be a form for patients to request their own records.
Right. They don't have to utilize your form. In other words, they can use any form or any type of request as long as it has all the information in there.
This is Kimberly again. Wouldn't this fall under the HIPAA right of access initiative in which they can send their records to anyone?
Well, send your records to anybody is separate from making them a personal representative. I think that it's two different issues.
I thought there was something in the initiative and where they can make someone a representative. I agree with Sharon. It is very risky. I personally wouldn't want to do it, but that doesn't mean it can't. It either way. I thought that I saw something in there.
Well, you can designate someone to receive your records. That's one thing, but to make them a personal representative you'd have to look at the state law to see whether it's allowable.
Thank you.
Yeah, I don't know if the person who asked this question is on the call today, but if they are, like, have you checked your state laws, like Sharon mentioned, like, because that's something that definitely needs to be done. So I've also not heard of Chart Squad, so I'm not exactly sure what they do, but yeah, I mean, submitting your records to one person, like to a company, is one thing, but yeah.
Sarah, I just jumped on, this is Joni. I just jumped onto their website. You really ought to take a look.
Yeah,
That's
Sarah,
amazing.
sorry, this is sorry, this is Sandra. In my old hat, when I was the director of medical records, release of information vendor, we worked a lot with Chat Squad. So Chat Squad is a service, to my understanding, and they work on behalf of the patient, but they can't be a personal representative from any of the hospitals that I had worked with, because a personal representative required that someone would be there. You can pick up the phone, you can say, hey, Mary Sue is in the hospital, etc. And they would be able to add some sort of benefit. So it's really a service, and it's a paid service. And they work with a lot of litigations, a lot of lawyers for records, and then they charge back a fee to the patient. So this is really a service. So I would personally say no. And they are a tricky requester. So they try to, get under the radar in certain states, and they go to the OCR quite often.
Wow, Sandra, that's really good information. Thank you. And I'm definitely going to check out and see who they are. So perfect. Are there any more questions or insights? I can see things coming through the chat. I may need to go and change my glasses. I can't see it. Cheryl, are there any questions that are coming in the chat?
Well, there are comments coming.
Okay.
I do have a question. Does the patient have full rights to authorize a personal representative irrespective of state law? Example, especially to ensure a DNR, etc.
Oh. And again, that's going to really depend on the state law, on what the law says on how you can actually appoint a personal representative, right? So I think that HIPAA really defers a lot to what the state regulations are. And I know some states like Illinois, like your spouse is automatically considered a personal representative unless you opt them out and say, utilize your right to have a privacy restriction in place. So I think you really need to check on that per state.
can I ask a question?
Yes, Melissa?
They were also asking, requesting behavioral health records. Now, in New York State, they ask if you're looking for behavioral health records that you have to sign a specific type of request. With the CARES Act, is that impeding patient access? Because
With the CARES Act, no, maybe with the, well, I don't even think so with the Cures Act, because that would
Cures
be a
Act.
privacy exception, right?
right.
Because under the Cures Act, there are 8 exceptions on how you can deny a request or withhold information. And that would fall underneath the privacy exception of the Cures Act, most likely, right? You would probably not be interfering with access to like electronic health information if you did it because you have a state regulation that requires additional authorization for that. I also think that it's important to note if they're requesting behavioral health records that under Cures as well as HIPAA, you have the right to withhold psychotherapy notes and not share that information. So it really, and then you also have to consider behavioral health as kind of a broad stroke. It could also include 42 CFR Part 2 records. And you have to, again, under Cures, it would be under that privacy exception because you're allowed to refer to another federal law like Part 2 that states you need additional authorization in order to release that information. So I think that it gets really sticky. There's a lot of what ifs inside of this question. So I would highly suggest that this person here reach out to Sharon and see if Sharon can help you walk through the whole scenario. Sharon, I'm kind of just throwing it out to you. Sorry. Right.
Thanks.
And I did notice that I had skipped through. I have like my little highlights down here. I skipped a question, so I went back one. All right. So here we go. I was hoping to maybe receive information regarding our obligation to allow for a patient to review and or receive copies of external correspondence regarding their care. So I actually spoke to this person. They mean notes from other providers that they have inside of their EHR. If we have an obligation to provide access for review and or copies as an organization, do we have to notify the organization where the document originated for their accounting of disclosure tracking? And so this is a scenario that happens a lot where people request access to their records and you have consultation notes from other providers. You have, maybe some narratives on imaging results that came from another facility. And so I think the Cures Act is very clear that those narratives are included in the US CDI that need to be disclosed either to the patient or to another provider, right? But if we're talking about those consultation notes, I would be very interested to hear how other people are handling this. Okay, so my suggestion is always to define out in your designated record whether or not consultation notes from other providers are part of your designated record set. If they are considered part of your designated record set, I would say that you have the right to disclose them. I do not think that you need to alert the other facility. That is causing an unnecessary administrative burden. I think that you just notate in your own accounting of disclosures what was disclosed. If you do not include consultation notes in your designated record set, you could likely, depending on state regulations again, withhold that information when providing records requests.
Hey, Sarah. Sorry.
Yes, Pardiv.
Yes. So if let me ask you a question related to this.
Okay.
You already have the answer. I'm going to just clear the cobwebs in my head here. So it's a violation to look at your own records, right? If I'm a hospital employee, correct?
Yes.
Yes.
So then, and what's the reason for that? And the reason I'm asking the question is if I can disclose notes with the, one thing is when you're meeting with a doctor, they put a lot of notes in there, right?
Mhm.
And it's for them and whomever your case is transitioned to. It's not for your eyes, right?
Right.
Right. So if you can allow, if you're changing the regulation where some states can say, hey, you know what, you will get that information with your notes, then you know what, I'm not actually, I'm looking at my own records, I'm not doing anything wrong because I can get access to the information anyhow in that specific state, right?
Right.
You should probably follow the process, though. You shouldn't just go in and do it yourself. You should get the written authorization and go through the proper channels. I would hate for you not to do it the correct way.
No, and again, I'm just raising a question. I'm not asking people to go and do this, but I'm just trying to look at this from that perspective. So, Sarah, I don't know how much you have on your plate there, but whenever you have a minute, I'll go back to the previous question because another comment on that one, but we can wait till
Okay.
the rest.
Sorry, this is the previous question. Mhm.
Yeah, so this one is interesting for me because my hair just stands up because from a security perspective, right? In terms of information being sent to, how do you define child squad as a business associate? From a representative perspective, you're sending them all the data, number one. And number two is who validates that they are the right people who say who they are, and you're sending the information to those people and they're going to do what they say.
Right. Well, and the thing is too, is I think that this is a third party app that the patient engages from what Sandra said, right? So from that perspective, they would not be a business associate and the patient has the right to say that they want to send that information over to a third party app. And once the new HIPAA privacy regulations come into place, then we have to really consider what that's going to do for us because the patient will have the ability to do just this.
And
They will have the written right to do it. Yeah.
no, I know, but it opens up a can of worms out there. So
I'm sorry.
it opens up a can of worms from a security perspective and also from the patient safety perspective, because this can be used in 100 different ways. You know what I'm saying?
Right. Well, I agree with you, right? I think this is one of the biggest problems that we have with some of these third-party apps actually not falling underneath HIPAA.
Right.
But that's a whole other debate.
Right. Okay, I said enough. I'll go on mute. Thank you.
Thanks, Pardiv.
I would comment, Sarah, this is Joni again, sorry, on Partiv's comment about what would prevent him from getting in and looking at that medical record. I can tell you from my perspective as an auditor, I'm getting in there and I'm looking at who's touching that chart, and there's not going to be a minute that I don't pick up the phone and say, what were you doing in there? Why were you in this medical record at this particular time? I'm going to ask. There has to be a legitimate reason.
Right. I agree. And I think that that highlights the importance, Joni, of exactly the work that you do, right? So you're one of the most proactive compliance officers that we work with, where you're actually going in and actually looking through all of your records. And I think that that's really important. And this kind of highlights that need. So.
And Joni, I brought that up just to be sure that people realize that you don't have a free card to just go and do what you want to, right? In the sense it's not allowed, and then you should be doing it. But just that was a devil's advocate question which I raised. So thanks for answering that.
Awesome.
Hey guys.
Hi,
Can you hear
MJ.
me?
Yes.
Hey, I was just sort of back on what you were just talking about, and I don't know, maybe I'm looking at it a little bit too simplistic, but and I know ancient years ago, and I know it'll tell my age too much, but I know it was looked at a whole lot more strict as far as, you know, if it was information from some other provider, you absolutely, you know, you still couldn't release it or whatever. But my understanding now, some years ago, it changed somewhat into the fact that it's now, once you received it, it's considered, and that is unless maybe there is information that you receive in your record and you're not using it for treatment. But once you've received it, it's interpreted that you're now using it to be able to treat that patient. So that information that you have, it is in essence your record now. So yes, it maybe came from an outside source, but you've received it because that is something you're using to conduct treatment of that patient. So
right. And
that's why you are able to then disclose it, or if people ask for copies or view or whatever.
Right. And Mary Jo, that is specific to Texas, right? So, because I know like you're in Texas and that is a Texas state regulation. To my
I did
knowledge,
not think
there's,
it was just Texas, but okay, if it
yeah.
is, I did not think it was just Texas, but okay.
No, New
Yeah.
York did the same thing.
Stand
Oh, did
corrected,
New York do the
please.
same thing? Yeah, I was like, it's really based off of state regulations, right? When we start to look at that, which is another reason
Okay.
why, like, but it highlights another reason why it's so important to determine what your designated record set is and to
I agree.
consider not just what HIPAA says you're allowed to do, but also looking at your state regulations so you don't miss these types of things that Mary Jo was just talking about and that Melissa just mentioned that New York does the same thing as well. So really double check into those state regs and make sure that you are following that.
It was quite difficult at times because sometimes you receive information after the patient's already discharged. So then you have to really say they weren't part of treatment because they didn't arrive on time. So then it's like,
yeah.
So I made my girls really look at dates.
That's really good, Melissa. Awesome. All right. So next question. This is an Information Cures Act question. Is the open notes mandate required, and how many days till the notes need to be posted on the portal? So one, Cures does not require you to post on a patient portal. There is no requirement for that. However, if you are routinely pushing information to the patient portal, you are not, it would likely be considered information blocking if you selectively choose what information, what notes, what lab results, or if you're withholding information for physician review before you post it to the portal. So make sure that if you are posting information to the portal, that it's done non-discriminatively. I can't English today, y'all. This is my first week back to work after 2.5 weeks of walking pneumonia, so brain's still foggy. But non-discriminatively, we're going to say that that's the word. And like fairly across the board, right? You can't pick and choose which patients or pick and choose what information you're pushing to the portal. Open Notes also requires immediate access and free access to certain elements, right? And I'll be happy like in the follow-up to kind of provide what those elements are. But those elements need to be disclosed immediately upon request, right? Which doesn't mean they have to be immediately pushed to the patient portal, right? You'll follow a regular policy for that. So any questions or comments on this? Because I know everybody has a lot of questions on information blocking.
Yeah. So if our discharge summaries aren't due for 30 days, then do we have to adjust to what Open Notes and the Cures Act are requesting?
That would depend, Melissa, right? So if your discharge summary is due within 30 days, I'm assuming that's your MIPS requirement, right? Like your for MIPS.
Well, we're under OASIS, and that's really
OASIS.
the only
Okay,
one
so
that we have, which just changed it to 45 days.
Okay, so I think that would be okay. But however, if a patient before that 30 or 45 day notice, right? If a patient or another provider calls and asks for the discharge summary, you have to provide it. You cannot withhold it to allow the discharging provider to review the record. You can't say I have 30 days or 45 days to give you this information. They're calling and asking for it. Discharge summaries is one of the things that's on the list. And so Cures is very clear that it is immediate and free access.
Okay. Thank you.
You're
Sarah,
welcome.
Hey, Sarah, I had a question about that.
Oh, you look nice, Michael. Love your backyard.
Well, it's a beautiful day in New Mexico. I hope spring is coming for all of you wherever you are, but it's certainly here, although it's a little sunny. I wanted to ask about this specifically. You posted about that on LinkedIn so this free and immediate access. Can you clarify that a little bit? Because I was kind of assuming that, well, you still had the 30-day, or you still had some period of time where you have to provide the records, and therefore you could work it into your workflows that the provider will review it within that time, and then you're going to meet the deadline and you're fine. But it sounds like there's a new requirement here that where we don't have that grace period. Can you just elaborate on that a little bit for us?
Right. So, and again, this is a new regulation, so I'm going to put the caveat that nobody is an expert except for the ONC. And the ONC is constantly giving out new guidance. So from what I was able to understand in my millions of hours I spent pouring through these regulations is it does say immediate access, right? It also in certain areas mentions without delay, without undue delay, without reasonable delay, right? It utilizes those terms peppered throughout the information blocking mandates, right? It also has criteria like for exceptions, right? If like the content and manner exception is probably going to be one that we see a lot. And I think that is really important to consider here too. So what you look through is your exceptions to see if you can qualify for an exception to delay the information from being released, and that you have a set policy on how to do it, again, fairly across the board. But it's really coming down to where the OCR, the ONC, HHS, everybody is really looking to ensure that we have this free flow of communication and that there aren't these unnecessary administrative burdens, right? Because with the adoption that we have of all these health IT functionalities and technologies, it's really easy to share information, but we have these kind of antiquated administrative processes that put those workflows and burdens on us, right? And then if you really think about it, how freeing is this going to be for us, right? Once we start actually doing this and allowing this information to flow so freely. How many times, I know back when I worked at the hospital and I worked in clinics before I started HIPAA Track, like half of my HIM department career was spent chasing down records from other hospitals and referring providers or providers whose patients were in the hospital and we needed information from them. When I was working in the clinic, I also spent so much time chasing down information. And then as a patient, I know it's extremely frustrating when I request a lab result, for example, and I don't get my lab results because the provider hasn't had a chance to look at them yet. And I'm like, come on, you don't have to have a provider to send me my lab results. I need them because I'm going to this provider, and you won't send them to this provider because you're requiring me to sign an authorization to get the records to that provider, and I don't have to. And so that's all of this is what information blocking is seeking to eliminate. And it's really going to be freeing. And we may be scared of it right now because we don't know and it's new. But I think once we start to implement all of this, it's really going to be so freeing. All these workflows and burdens that we've been complaining about and blaming HIPAA on will no longer be in the way.
Right.
Sorry, little soapbox speech over. Sorry, Michael.
No, I love that. I love that soapbox. I share your optimism. I think that sharing information is the solution, right? But I also know why doctors are afraid of this. They don't want you getting your lab results and go doing WebMD, and now you think you got cancer and you're freaking out and all of that. That's what they're trying to avoid. But I don't know. This is a lot deeper than just an administrative. Can we get the data moving faster? Can we do better than a fax machine? This really goes to the heart of some major cultural issues in healthcare about the authority of the doctor and the right of the patient. It's really interesting, and I think there's going to be a real cultural crisis here, way beyond the technology issues. I think we're really going to be making doctors question themselves and what their role is, and same for patients. It's going to be interesting, I'll say.
I agree.
I think there'll be technological change because you will look at blockchain. You will look at ways of being sure that things are in sync and that you can move at a much faster pace. So I think that change is coming. I think whether we like it or not, absolutely it'll come. I don't know how fast we'll adopt it and adapt it, but I think I can see it on the horizon. So that's just my own personal opinion, though. So.
Right. It's inevitable. Information sharing, it's inevitable. You better get behind it now and you better figure out how to adapt. And if you can't figure out how to adapt, retire early. Right?
Thank you. I'll do so. Thanks.
All right. So
this is Cheryl. There was one comment, and it's pertinent, I think. What about labs that take time to become available? What if those have been requested and they haven't been even reported back? And so I want to lump that into what about all the data that maybe hasn't been made available, period, yet, and the patient thinks it should be. How are we going to deal with those situations?
Right. And that I think is something that even the ONC, so I was on a webinar, not last week, the week before, that the ONC gave on this, and that a very similar question was asked, right? And I think that you explain to the patient that the lab results aren't in, right? Like when I think most patients are reasonable and they will understand like, okay, you don't have those results. So obviously you can't share them with me. I can't share invisible data, right? But I think that it needs to be very clear that we don't slide down the slippery slope of telling patients that the lab's results aren't available or you haven't received them back yet because the provider hasn't reviewed them, right? So you have to
So I think,
sure, you have to make sure
policy.
Yep. If you have the data, you share the data. If you don't have the data, there's no data to share, right? So.
Yep. Okay. Thanks.
Awesome. No, thank you. All right. When a resident in care requests daily notes given to them each day of residency, do we need signed authorization for release each day? Similarly, when a family member requests a monthly update for the entire stay of the resident releases each time. Okay, I'm trying to unpack this question. Okay. So I'm assuming this is from one of our LTC, long-term care community members. So if a resident in care requests daily notes given to them each day, do we need a signed authorization for each? Okay, so patients don't need to sign an authorization for them to see their own records, right? If they've requested daily access and you have the technical capability of providing daily access, I guess so. You could provide that access to them every day. If a family member requests a monthly update of for the entire stay of the residents release each time. Okay, so again, the family member, if they're considered a personal representative, they have the right to request the access, and under Cures and HIPAA, you're required to release that information. So I think the family member, you would need to double check to make sure that they are a personal representative and you have that authority to release without asking for an authorization each time. So I think I've answered the question.
Yeah, just to add a little bit, I think it depends on the role of the family member, because if the family member is involved in the patient's care, then you wouldn't need to have documentation of the personal representative status. So it's really, but you also, what you would want to check is that the patient has not said, please do not give my records to that family member.
Right, and that would be the privacy exception of Cures.
Yeah, it's also in HIPAA.
That is true too, Sharon. Yes. I'm so in Cures right now because that's what my brain's been doing all week. So
it's very fact specific.
Yeah.
Yes.
We ask for a separate one each month because each month you don't know what happens. You can't do it. You can't foresee the future. So you can't honor something that's so yeah.
You have to be very careful with that, Melissa, though, because if you're requesting an authorization from the patient every month in order to disclose it to the personal representative. Yeah. If you're requesting that every month, you have to be very careful that you're not falling into a potential information blocking situation. So,
well, the personal representative would have the same authority as the resident themselves.
Yes.
It would be the family member's request. I would have them sign it each month because, again, you can't foresee what happens in the future.
Exactly.
Yeah, I guess I would take it a little differently.
This is.
Sorry.
This is Carlene. Can I say something?
Absolutely, Carlene.
It's my first time on the group and I'm loving it.
Welcome.
Thank you. But I'm thinking if it's a family member that's involved in their care, typically we have the participant or patient sign a release that's good for a year. So if that release is good for a year, then there's no need for monthly release signing.
Right.
So that's how that will be handled.
And again, I think back to Sharon's point too, if the family member is involved in their care, they're automatically considered a personal representative, right? And so in that
No,
case,
not
No, not
necessarily.
quite.
not
No,
necessarily.
not at all.
No, I think there's a couple things. One is if the family member is involved in the patient's care, the family member can receive PHI.
Correct.
Has the right to do that. However, lots of organizations require documentation just to make sure that they're not crossing any line. And you do never know what happens within a family. There could be 1 month, it's okay to give it to my spouse, and the next month I'm divorced. So, or going through, so it is good to keep checking regularly. With a personal representative, I'm not sure who said it, a personal representative stands in the shoes of the patient. So
Right.
a personal representative has the right to access the records.
Yep.
All right, perfect. Awesome. So moving on. All right, so a physician does a psych eval for police department for new hires. The doctor wants to block these notes, says the notes should never be released to the patient because the police department pays for the evaluation. I disagree. I can't find anything in the HIPAA or Cures Act to permit this blocking. So unpacking this one. So one, it's a psych evaluation. So
Hi, I'm Kelly. I'm the one who submitted this question.
oh,
Kelly Stone.
awesome, Kelly. Do you want to give any more information on this before we try to take stabs at it?
Yes, if you don't mind. One of our physicians does like pre-employment psychiatric evals for the police department around here. And so it's like a pre-employment physical type situation. But he's a psychiatrist, and it's just the eval. And with information blocking coming along, we've been educating our providers on what they should and shouldn't block in Epic. And this psych provider wants to block these from going to my chart. And he actually says that we shouldn't release them on paper either. And his reasoning for that is strictly because the police department, the new employer, is paying for the valuation. So
Right.
I need this,
See, and then like my question probably to Sharon, is this employee information or is this patient information? Because it's done as part of an HR process. So is it even PHI?
I think it goes on. I mean, I don't know for sure. This is just a gut overall question, and I wouldn't rely on this. But to me, it seems like that's not a reason to block the notes, is who paid for them. I don't think that comes into play. But I think the psychotherapy notes exception is the reason that you would deny the notes to the patient.
right. Does a psych eval for a pre-employment fall as a psychotherapy note?
Well, because the definition of psychotherapy notes, I just looked it up. Well, hold on a second. It says notes recorded by a healthcare provider who's a mental health professional documenting or analyzing the contents of a conversation during a private counseling session or group. So the question is it a counseling session? And I think I would defer to somebody who has more experience interpreting that provision of HIPAA. Arguably, it's not a counseling. So let me ask a question because I don't actually know the answer. If you were in the situation, if you were doing a pre-employment physical, would you deny the patient the right to those records?
I mean, if we're following this doctor's logic that he isn't releasing these based on the fact that the police department pays for it, then I'm sure he would probably think we should block a physical examination as well. But I know, as you know, working with this before, that employers cannot refuse to release patients or employees' health records.
Right.
I want to chime in if I can, Sarah. I'm trying to find the citation, but I know the physician's logic, in my opinion, is completely wrong. Again, I don't know about the
I agree,
psychiatric
Michael.
issue, but whoever paid for it is 100% irrelevant. And I have seen if you look at the HHS wall of shame, there is an enforcement action on there that is crystal clear model. If you can find that and show it to the physician, he's wrong. That logic is wrong.
Yeah, I think that it just becomes, and I agree with you, Michael, that the logic is incorrect, right? That it doesn't matter who pays for it. I think that this needs to go back to, is this PHI or is this HR, right? Is this employee information, right? And that is what I think that the heart of this issue could be, is it depends, right? So there are, I know when we worked at when I worked at the critical access hospital, we had an office, right, of one physician and some staff that all they did was pre-employment physicals for various companies in the county that the hospital was in, right? And that's all that office did all day long, every day. And that information was segmented in our EMR. It was in our hospital did not consider that PHI. They considered that something completely separate. Even though a provider was doing it, it was completely segmented off from the rest of the data, because if that patient were to come into the hospital for another issue, their pre-employment physical is not PHI that we would have had,
Right.
Yeah, I'm not sure that's a correct. I just don't know, but it seems. But I guess the other thing is, in the employment context, if you're doing a background check on a person, there's federal consumer, the FTC gets involved in terms of what the individual has the right to see if you deny employment based on, say, a credit check. So I think it's a bigger issue that it sounds like those of us on the call can't answer completely.
I know, we don't know.
Well,
I'm sorry, Kelly.
Oh, that's okay. I just, my first instinct was to say that these patients could get a copy of their psych eval from their potential employer, the police department, for example.
Yes.
But that, I just don't feel like that lets me as a HIM director off the hook if that patient would happen to call us and ask why we didn't push it to my chart with information blocking. I'm just not sure that we're allowed to block that. So, okay, well, I think what I'll do next is have this taken to legal for us and see if we can get
do that, Kelly. And I'll also continue to do some research on this because I'm probably going to reach out to Dina, who's unfortunately not on the call, because I know that she has worked with employment stuff before. So let me reach out to her and see if I can at least facilitate an introduction between you and Dina.
Okay, that would be appreciated.
Say something. This is Connie. I've never been on this before.
Hi, Connie.
Hi. And I heard you talking about psychotherapy notes. And that definition that's in that HIPAA rule maintains that they are outside of the regular record. If it's a psychotherapy note, it's not the note that necessarily is the counseling note. It's something that's kept outside of the record. And that can be requested.
I agree. Hi, my name is Angel Shreves, and I am an HIM manager. I supervise medical records for a mental health, behavioral health, substance abuse facility. And you are correct. We interpret psychotherapy notes to be Post-its and legal pad notes.
That's correct.
And think that they use to analyze the session and to come up with their diagnosis and prognosis and treatment. That we do not share, but if it's a progress note that contains medications, diagnoses, any other information, and we document it in the session in the EHR and make it billable, then yes, it's PHI.
Okay.
Well, thank you for that, Angel. I do agree with you on psychotherapy notes doesn't really determine what mode or medium you're utilizing to create the psychotherapy notes. I think what Sharon was trying to ask is, are these psych evals psychotherapy notes? Are they even psychotherapy notes? Because there's
Hey, Sarah.
Yes, Mary Jo?
Sarah, part of my question would be, you were asking earlier, and I don't know, I can't speak for whatever the hospital previous to it, but isn't part of it who the provider is? When you were saying whether it was, is this really employment versus is it PHI? If the police department, let's say, contracted with that doctor, and the doctor goes over to the police department and, hey, this is Joe Doctor doing it with the police department, and all of it stays at the police department, I could see that would be employment that the police department had. But if they're coming to your clinic or you're coming to your hospital, don't they become a patient no matter what? So it seems like even if it's whatever they're doing, if they're receiving some sort of evaluation or service, that becomes a patient, even if it's a minor eval or screening, even that becomes a service. So I mean, I'm not saying as far as this part of it or how you release it, but I was trying to figure out how can you distinguish, and we're going to say, we're going to sit these over here. We're not going to call those records.
I agree. I think it's records. If it's going in any type of healthcare entity's database, like a hospital or a clinic, and it's like you said, an assessment or evaluation, that's considered PHI.
Okay.
Yeah, I was going to jump in there too. The definition doesn't make a distinction for the purpose. It's any identifiable health information that's received or maintained or transmitted by a healthcare provider.
Okay.
So there are two comments that I think are pertinent. This is Cheryl. One of them is, what is the employee patient consent off signing at the time of the evaluation? We haven't talked about that at all. And the other thing is, when you figure out what the answer should be, people are posting, they want to hear back what you find and decide. So, or Kelly finds and decides, not us, but what Kelly finds and decides.
Yep.
Thank
so
you.
I will actually post this on the HIPAA Check community so that we can all kind of go back and forth on this then. So this will be posted to the HIPAA Check community on that URL that I mentioned at the very first of the call, and then we can see how everybody is kind of weighing in, and then we can probably get to the bottom of it there.
Can you repeat that URL, please?
It's hipacheck.com/community.
Sarah, will you let me soapbox for just 1 second? I just want to say that regardless of the legal issue, the idea that an employer could have data about me that does not belong to me is offensive. The idea that a doctor can have information about me that doesn't belong to me is just offensive. It's just not right. So let's advocate as a community for that patient right of access. I just want to say that.
Thank
and
you.
I'm clapping in the background.
Yeah, I agree.
All right, awesome. So, guys,
and if the police have information about me and I don't get to have it, that's triply offensive. So there's all kinds of ways I'm offended by this doctor's logic. The idea that a doctor can have information about me that doesn't
we have a weird echo.
is just offensive.
So
time delayed echo. That was really weird.
Yeah, that was weird.
It's a rip in the space-time continuum.
That's hilarious.
We were supposed to hear that a second time.
So here, I want to make a note. So we have 2 minutes left in the huddle, but we have 1, 2, 3, 4, 5, 6 more questions. We took a lot of time going through those first, several questions. So I am going to hang on and get through a few more of these questions. So I'll say we'll go 15 more minutes. So if anybody wants to hang on for an additional 15 minutes, please do, because we do have a lot of content. Anybody's question that we do not get to today will be posted on the HIPAA Check community, and everybody will receive. I can invite everybody to the community at the end of the day today as well. So everybody will get this. All right, so next question. What is the best practice for implementing a clean desk policy? Leaving notes around nurse stations and computers in regards to patients is an issue at our hospital. This is still going on, right? So it's been 10 years since I've worked in a hospital and it's still an issue.
People never change.
People never change. Those darn sticky notes. Okay, so the best practice for implementing a clean desk policy, in my opinion, is what I always preach to all of our clients. If you're a compliance officer, if privacy is one of your main roles, and implementing a clean desk policy is at the top of your priority because it is an issue in your practice, you need to practice what I call GOO, G-O-O, get out of the office, right? You have to get up, walk around, and actually tell people when you see things where people are leaving patient notes and things around their nursing stations and computers. You just need to make sure that you're telling people and creating that habit. That is, in my opinion, that is my best advice, is GOO. Anybody else have some information on how they're actually implementing a clean desk policy?
Yeah, at my job, we have what we call the HIPAA environmental assessment, and it has a checkoff of any HIPAA violations, such as Post-its on walls or desk or in open areas. And if this is seen there, then there has to be a plan of correction. And they have to submit a written plan of correction.
Sarah, I think it goes beyond Post-it notes, right?
I think so too. I think it's
because I've done, I fail to remember how many walkthroughs I've done. And what I found everywhere I go, and please don't get me wrong, is the offices are left open, the drawers are open, the purses or the briefcases are left there, the badges are left on the table. I mean, you're talking about, it goes way beyond Post-it. Once I get access to these things, it's just fair game out there for me then, right? I have access to everything practically. So I think one of the ways one of my clients did that was made sure that people followed what was taught, and they checked on their efficacy. And I was there from 1 year to the next. It was a 180-degree turnaround where people were empowered to basically, not policing in that sense, but at least letting the associates know, guys, you can't be doing this. And rank and file didn't matter, right? And that's the best part I saw out there. So I think you got to be careful what people do out there, because people tell you that, hey, I just stepped in for office for 1 minute. That 1 minute you might be caught by somebody at a conversation, something happens, 1 minute up to 30 minutes, right? Or 20 minutes. And then you leave that thing open for people to access. So again, that's something else which I would recommend, but
No, that's a great point, Pardiv.
Part of my experience was focused around the education and also embedding the need for awareness as part of the culture. And it was, I just put in the chat there, it was explaining the why that it should not be a continuous habit, and also looking at their behaviors. So what was key was actually getting collaboration and agreement from leadership, and then actually getting, bringing more of, I suppose, the champions of understanding, who were those that understood why this can't happen continuously in this world of digital transformation. And then secondly, it turned out quite funny actually, because it was agreed across the organization to have a name and shame culture, which, and it was agreed. So therefore you would have CCIOs, different, clinicians actually going around and putting a name up on a board. And it really it fostered greater friendship, and it actually had a healthier culture, but the outcomes were quick, really, really quick.
Yeah, your own personal wall of shame.
Yeah, but I tend to sort of have slight disagreement there, because I think negativity might not be helpful at times, because it depends on each individual reacts differently, in the sense, some might say, gosh, there's something wrong. Some might say, holy, you might an unwanted reaction. My take would be the other way around, but I would put names up there of people who did a great job. Strive for that, right? The second thing I would do is, you're right, absolutely right, champions. Who should the champions be? They should be one of the rank and file. So whether it's the nurses, whether they are the registration desk, I'm just putting things up there, is from each of those areas, you got to pick somebody who's going to lead, and then others will follow simply because they're one of their own, right? So that I found pretty useful too. But again, just my own personal opinion. But again, for whatever it's worth. So.
Oh, awesome. Thank you, Pardiv.
And
And I
Sarah,
agree.
this is Joni. I can just tell you a fun way to do it. I mean, I've done it before and it works out pretty well. You can order a badge, an actual badge for the HIPAA police. And you can do your HIPAA police walkthrough once a month or whatever. And people look at it more as a friendly thing instead of getting upset, because I understand that stuff gets laid out and gets left out. But if you have someone routinely going around with their HIPAA police badge, the girl that I had do it in the job before this one actually had a little toy belt, and she had little guns in her little belt, and she like pew, pew, would like shoot at people. It was pretty good fun, but it reminded people.
And I would agree with what Hazel said about the why. I think in the training and your awareness messages, letting people know what can go wrong, because otherwise it's just a bunch of rules that are slowing down their work. But if you explain to them how it can actually impact the patients and how these breaches happen, I think that goes a long way.
All very brilliant implementation things. So thank you, everybody. Awesome. All right, so I work for a care coordination organization / home health that provides care management services for individuals with intellectual and developmental disabilities. I was contacted today by a care manager that they received a request for records from Medicaid that is out of state. The request was for records for an individual we no longer serve. They moved. Typically, I know that insurance companies fall under the payment portion of TPO, so an authorization is not needed. But seeing as we don't have record or knowledge that this is their insurance company, as well as we no longer treat the individual anymore, it's making me question it. We are unsure what exactly they are looking either, since they did not provide that information. Okay, so I'm not sure what the actual question is.
So I would say first, if you receive a request from someone you don't understand, I would hope that you would contact the requester and get more information as to why they're looking for it, verifying that it's not a scam. So I would start with making a phone call.
So this was actually my question. Hi, it's Shana. I didn't know I was going to be on here either, because actually right after I sent it, I did some more digging and ended up figuring it out.
Oh, awesome.
It was because they're, we're applying for Medicaid out of state. They were actually asking for records that the individual didn't even receive, like they disenrolled with us around that time anyway, so we didn't even have anything to give them. But it was just a very strange thing.
Right.
Of it and everything. I mean, no one ever had that happen without prior knowledge, so it ended up being worked out.
Awesome. How did you work it out, Shana?
Well, I mean, we didn't even have the records, so since they did send us authorization, which it was a Social Security, it was for Social Security and Medicaid and all that. So they sent an authorization, and they were only requesting 1 day worth of notes, and it was really strange. But yeah, we ended up not even having anything since they weren't even receiving services with us at that time.
Oh, awesome.
We kind of lucked out, I guess.
Awesome, Shana. Great.
Yeah, thank you.
You're welcome. All right, so this is probably going to be our last question for this month. And again, everything will be posted up on the community that we didn't get to. So my apologies to anybody whose question we are missing. So within information blocking, there is a section that clearly outlines the notes that we are required to share with the patient via the patient portal. This section also specifically calls out 2 types of notes where this does not apply. The exception categorized as information compiled in reasonable anticipation of or use in civil, criminal, or administrative action or proceeding. From a risk and privacy perspective, how would an organization be aware if a note related to a patient's labor and industry injury or motor vehicle accident, cancerous diagnosis, et cetera, could be part of future legal action? So I'm going to break this down a little bit. 1, there is no requirement for you to push information to a patient portal in cures and information blocking. So you are not required to push any information to a patient portal. But if you do push it to the portal, like I stated previously, it must be done in a non-discriminative, which is my new word, manner. And it needs to be done without holding certain information for review. That's number one. Number two, the exception that is like this exception, information compiled in reasonable anticipation of or use in civil. I'm actually going to hold on just a moment, like get out of this, go back to that specific question. So I have it pulled up. That is not an exception. I am going to pull out, because I'm actually working on this slide. Hello, everybody. I get to see everybody. I'm just going to share my whole screen so that we can see. So this is a slide deck that Erin and I are working on for a presentation tomorrow. But here are the 8 exceptions under information blocking: preventing harm, privacy, security, infeasibility, health IT performance, content and manner, fees, and licensing. Those are the only exceptions in information blocking. So I don't know where this information compiled in a reasonable anticipation of or use in a civil, criminal, or administrative action or proceeding is at. Because when we look at preventing harm, like it is very specific that it needs to be for you're withholding information because you're afraid that that information will cause a reasonable belief that the patient could be at harm, either physical harm, or their life is in danger by sharing that information. That's this exception. Privacy exception is basically allowing for other federal, state, and local privacy regulations that you can actually have an exception for that. Security is, again, very specific to your security. So I'm like trying to think of where this exception came from, and I can't, like, there's not anything that I can recall for this. So whoever asked this question, or if somebody else is aware of this exception, because it's not one of the 8 exceptions that made it into the final rule.
And that, Sarah, that typically is language used to this when we're talking about attorney-client privilege or attorney work product. So I'm thinking that the concepts may have gotten mixed up here.
Yeah.
When
I think that what we need to do is maybe work on getting an information blocking webinar out to our community. So that is something that I will collaborate with our other experts and I will announce it as soon as I have something done. But I think that all the questions from this month has highlighted the need to do an information blocking webinar. So we can clarify this.
This is Mary, and I think it is mixed up. That line comes directly from the HIPAA privacy rule.
There you go. Thank you, Mary. I was like racking my brain. I was like, I don't remember this, except I was so in information blocking, I wasn't even thinking about HIPAA.
Right.
So
this is usually done if the record is in a civil, criminal, or administrative action. That's usually if something was left in a patient when surgery was done, if complications were excessive due to the nature of the incident. Those records are usually taken out and put in administration to begin with. So that would be the only thing that I would consider. But again, the patient still has a right to have a copy of the records. I don't know. I'm confused with that one.
Yeah.
Yeah, I wish I could remember the citation in my head, but I don't have it right now. But it is listed in the HIPAA privacy rule under patient access. They request the records, and this was an exception that was listed there.
Yeah, and you're right, Mary. This is an exception that's there. And I think that what needs to, and again, like I said before, like Cures is still still brand new, right? So I don't think that anybody can really claim to be an expert yet. But what we can do is, with your permission, I would like to utilize this as a talking point and do an information blocking webinar, and we can actually do a little bit of digging and figure out the answer to this. So, all right, perfect. So I'm just going to skip through because all those questions that we just skipped that we didn't get to, again, will be posted on the community. Everybody will receive a copy of the deck today, a copy of the recording link, and an invitation to the HIPAA community, as well as for our webinar with Matterform next week. Thank you, everybody, so much for participating in today's HIPAA Huddle. We meet, for those of you that are new, we meet once a month on the third Wednesday of every month at 1 p.m. Central Time. And we are so happy that all of our new folks joined us. Yep, so if there are any last comments, questions?
Yeah, is there a compliance huddle you're aware of? For fraud, waste, and abuse?
Oh, you can feel free to submit those questions here as well. Even though we're called HIPAA Trek, we focus on everything compliance. So we've had questions that are non-HIPAA related in the past, and we'll continue to accept those questions because what you have here is an active audience of all of your peers from across the country that can actually help facilitate different questions and work through issues.
Awesome. Thank you.
Yep. For those of you that don't know how the HIPAA Huddle works, is every month, all these questions are actually created by our community members, by all of our huddlers. They are not created by us. And so if you have any suggestions on questions, or you have questions you want to pose to the community, you can either post them on the HIPAA Huddle section on the HIPAA community, or you can email them to cheryl.larson@hipaatrek.com, which Cheryl also will send out email. Jane will send out an email actually prior to each huddle with that email address on there. So
is that Cheryl with a CH or SH?
How about if I just type it to the chat? Yes. Trying to see.
Yes, it's
actually,
Cheryl with a
C
CH and Larson with an E. LARSEN. Hi.
Yes,
Oh, that's
like,
a really bad picture, though. That was really old. Sorry, you guys.
You look beautiful. So here we go. And I think, again, because I have on my, I can't, like, the Zoom needs to do something about making that chat bigger for us old folk. Like, I can't see. I think I typed it in correctly.
Yes, you did.
Awesome.
Awesome.
Okay.
Thank you.
Perfect. Thank you guys so much. I greatly appreciate everybody's time. Bye.
Thanks. Bye-bye.
Bye-bye.